Right. It's the first chance I've had to say anything in a day and a half here because I realized far too late that you had to be putting up your hand to say something before anybody had even finished speaking. So I haven't managed to get a word in until now, so this is my chance. Mike, thanks very much. Mike, thanks very much for having me here. It's an absolute delight to be here with you, see old friends like Larry and Steve, and to see a bunch of people, some of whom I'm familiar with their work, and others I'm not, but I've learned a great deal just sitting and listening and also talking to you folks, and it's been great. So the question is, what can I do for you in a very short 9 minutes, I suppose, that I have left? I want to talk a little bit about just situating Australia and Canada and as examples of constitutional interpretation and where they've gone off in different directions. And it's almost a cautionary tale for those of you, and I don't think there's probably too many in an originalist crowd, but for those of you that like to do comparative constitutionalism, you got to be very careful with it. There's some subtleties and some differences across these jurisdictions that are important. I don't want to get bogged down in that, but I want to highlight a couple of things. And then I want to talk about what I think is a very dangerous and bad trend that's going on in rights adjudication in particular. Jim touches on it in what he calls the egregious cases, and I agree with him. Those are egregious Australian cases. I'll talk about the way that's working in Canada, and I want to say a few words in particular about the concept of proportionality, or balancing, I think, as a lot of Americans call it and reject it. I'm sure most originalists reject balancing, but I want to talk about that and how that links in with rights interpretation and the sort of the enterprise of originalism. So, first of all, some jokes about Jim Allen. Jim is an original intentions originalist, and as such, he was banished from Canada some time ago, very early in the life of the Charter. When the Charter was passed in 1982, in 1985, the Supreme Court of Canada said, right, we do not do originalism. They purported to literally banish it. We do not do originalism. And they went for, as was discussed by Myman this morning, and a couple others have mentioned it, the Canadian living tree, which is the Canadian metaphor for living constitutionalism. Anyway, Jim was welcome sort of under pseudonyms in the country, but in general, originalism isn't welcome in Canada. It is more welcome in Australia. And let me say why that is so. Australia is exceptional, and I'll just situate this in terms of the Commonwealth model of legalism. Australia is exceptional in the world of things because it doesn't have a Bill of Rights. And so if I talk about who the similar countries are, Canada, New Zealand, Australia, UK. Canada goes for a Bill of Rights in 1982. And I've always described that as the Americanization of Canadian constitutional law, because what we did was we took the Westminster system and we said, here's a Bill of Rights, we're going to graft onto that, and we're going to give judges the power to strike down laws. And that was an absolute heresy. That just doesn't happen in the English model. And so you line that up against Canada, Australia, no Bill of Rights. Why no Bill of Rights? They wouldn't dream of giving judges the power to strike down laws. They can't even get a Bill of Rights just as passed as an ordinary statute there, because they don't even want judges pronouncing on laws. They think it's illegitimate. New Zealand and UK have bills of rights that do not allow judges to strike down laws, but can issue declarations of incompatibility. So the most a UK or a New Zealand judge can say is, well, I find that this law limits rights unreasonably or violates some provision of the Bill of Rights, and we're done. But there's no effect to that unless Parliament acts on it and amends or repeals the relevant law. So Australia is an outlier in that, no Bill of Rights at all. There's then the middle ground of Bill of Rights that are relatively weak compared to Americans. And then there's the Canadian model, which is much like the US model, except for the way we interpret it. And in that world of things, a couple of things happened, it seems to me. The moment Canada adopted a Charter of Rights, we started appointing different types of judges. Australia, never having had a Bill of Rights, remained a very positivist, formalist court, basically. So if you look at the types of judges on the Canadian Supreme Court and the Australian High Court, they're night and day. Absolute they're both called judges, and that's where the similarity ends. We appoint people that wouldn't be within cooey, as the Australians would say, of getting appointed to the Australian High Court. Conversely, in Canada, we'd say, well, you just got a bunch of lawyers on your court. People that have practiced law at a high level in Australia. That's not what you need to interpret a constitution. You need social activists. You need people from a whole variety of public service things. That's the Canadian Supreme Court model. Academically dominated in some ways, very unlike the Australian model. And so formalism persisted in Australia, and originalism had a lot of purchase there for a long time in interpreting a constitution. The difference between the Australian constitution and the Canadian one is that the Canadian one, pretty much like the other English models, says, look, all lawmaking power is given out to one level or the other government in Canada, federal or provincial. So there's really nothing to get too excited about. It's not a limited government model. Somebody can make a law on anything in Canada. And so in that model, nobody got too fussed about living trees, or we're just arguing about which level is going to make the law. Not so in Australia, and they were very careful about that, and formalism persisted, originalism persisted, what was intended in particular persisted. And as the systems began to diverge, what you got was, in Australia, I'll call it rights envy. They would love to be in the business that the Canadian Supreme Court is in, because it's fun. It's fun to do all the important cases, like on assisted suicide. Is that legal or illegal under the Constitution of Canada? That's in the court. Prostitution. Can prostitution be banned? Can criminals be stopped from voting? These are all Canadian cases. Polygamy. Is polygamy bannable in Canada? We're actually taking these claims seriously under the Charter. And they're hard, and some courts are issuing weird and wonderful decisions. The Australians can't do any of that, and they would love to, and their judges go to the conferences and they hear from the Canadian judges, and it's so dull. Damn it. And so, out come those three cases that Jim talks about, and they're heresy. They're ridiculous cases on any level. They're not even honest judicial craft, I wouldn't have thought. But that's what you get when you don't have a Bill of Rights. They will never get a Bill of Rights in Australia. You just heard from Jim how tough it is to amend the Constitution there. They can't even get an ordinary statute Bill of Rights that would give them some input in an advisory capacity. So what they're trying to do is infer from the Australian Constitution a set of rights. So they're going for what's called, respectively in England, common law constitutionalism. And there are those who think that, you know, you can infer any right from just basic commitments to the rule of law. It's a cottage industry at Cambridge University. They've got all kinds of people that write on this. You don't even need a Bill of Rights, which is convenient when you can't convince people to adopt one. So I'm listening to all the great popular sovereignty and other arguments and justifications for it. There's whole swaths of scholars and jurists who don't want to listen to any of that and just want to use whatever your Constitution already has to infer from, a set of rights from it, which would then give them the power over them. And that's the worst of the Australian model at the moment, and that's those cases that Jim was talking about. In Canada, we did all that pre-charter. The Supreme Court of Canada tried to go the implied rights route when there was no charter yet. And there's lots of very romantic dicta about the court protecting and this and that, and never a majority decision, all obiter. Lots of courts trying to infer free speech guarantees from basic commitments to democracy in Canada, things like that. Never attracted a majority of votes, and then we got a charter, and then they didn't need to make up things anymore. In Australia, they have to make up things. That's the basic difference between the two. So Australia has a lot of hope on the rest of the constitutional front in terms of being an originalist study. That's kind of interesting. And Jeff Goldsworthy's done some really interesting and great work there that I've learned a lot from over the years. On the rest of there's a real dichotomy, though, in terms of the Australian Constitution, rights and non-rights. And I think Jim is quite right to say, so I'm in agreement with him on most of this, originalism works well for a lot of things. It's not going to constrain them if you have people on that court that want to sort of make a Bill of Rights out of whole cloth. I don't think there's going to be majority support for that ultimately, but that remains to be seen. So let me stop there, and thanks very much, by the way, for at the end of the day, and then of a long and good day. I appreciate everybody that's still here to hear a little bit about Australia and Canada. So look forward to some questions.